summary of the facts of the case, or should I proceed with my first substantive summation?
Can you ask?
Yes, ma'am.
When you get the response.
Most busy. We turn to our first submission, which is that this honorable court has the jurisdiction to adjudicate this matter. To establish this court jurisdiction, we respectfully invite your lordship to consider three cumulative grounds. First, that the Supreme Court has that this honorable court has the exclusive original jurisdiction to entertain this matter and Article 1 of the Constitution. That the High Court lacks jurisdiction and Article 33(1) of the Constitution, and that the Child Education Board has the requisite standing to bring this action before this honorable court. With the court's kind permission, I shall now proceed to my first substantive ground, which is that the Supreme Court has the original jurisdiction to entertain the matter now before it. Your Lordship, Article 131 of the Constitution vests in this honorable court the exclusive original jurisdiction to entertain all matters pertaining to constitutional interpretation and enforcement. This applies the realization of the right of education. Moreover, under Articles 2(1)(b) of the Constitution, any civic-minded person can bring an action before this court in the public interest and to challenge acts or omissions made by this action.
So, in your submissions thus far, you're speaking about interpretation.
Yes, sir.
Are you abandoning the interpretation point to come under 2(1) because interpretation is not taking care of the 2(1)? Your argument has been just switched from interpretation to Article 2(1). And I'm saying 2(1) does not take care of interpretation. So, are you moving on to a new argument?
We are establishing the two rounds of the Supreme Court jurisdiction, the one on interpretation and one on enforcement. We just dealt with the interpretation jurisdiction.
So you are
moving on to the yes. So this principle was echoed in the case of Ejina versus Accra Metropolitan Assembly and Attorney General, where the applicant successfully brought an action and Article 2(1) in the public interest to challenge sanitation policies. And we submit that this is the same, we are doing the same as applicants in this present matter. As we bring this action before this honorable court to challenge the constitutionality of the acts of omission made by the state by failing to provide quality educational facilities. And we do so in the public interest as we bring this action for all the students who are suffering from poor educational facilities in the Western region and other rural areas in Ghana. So with the court's kind permission, I shall now proceed to my second substantive ground, which is that Article 33(1) is inapplicable and therefore the High Court lacks jurisdiction. Your Lordships, the respondents in their memorial in page 10 argue that the High Court should hear this matter under Article 33(1), which concerns the enforcement of fundamental human rights. However, we submit that this argument mischaracterizes the nature of the claim. Returning to the decision in the Federation of Youth Associations of Ghana versus Public Universities of Ghana, her ladyship, Adeyinba JSC, made it clear the difference between claims of individual human rights violations, which should be appropriately filed in the High Court, and those that require constitutional interpretation and enforcement in the public interest, which would fall within this honorable court jurisdiction and Articles 2(1) and Articles 131 of the Constitution. And we submit as applicants that the Child Education Board's claim falls at the latter, that is neither about a personal human rights violation, but rather it urges this court to declare whether the state's omission in failing to provide quality educational facilities amounts to a breach of the right to education. Moving on to my third substantive ground of my first substantive submission, which is that the Child Education Board possesses the requisite standing to bring this action before this honorable court. Your Lordships, we respectfully submit that the Child Education Board possesses the requisite local standard, and Articles 2(1) of the Constitution allows any person to bring an action before this honorable court to challenge the constitutionality of acts or omissions made by the state. We submit that in the case of New Patriotic Party, the Attorney General, the Simba case, it was interpreted as any person to include both natural and artificial persons, such that the Child Education Board, as a corporate entity established by laws under paragraph 9 of the Act, can challenge the constitutionality of state acts and omissions. Your Lordship, for this reason, we respectfully submit that this honorable court has the exclusive original jurisdiction to entertain the matter now before it. If there are no further questions, and with the court's kind indulgence, I shall now proceed to my second substantive submission, which is that.
So, since you are inviting questions, on your first submission, right, you make a point, and one of the points you make, one of the key points you make, is on working on interpretation, right?
Yes, sir.
But you started with the second submission, and your second submission on the that's not on this.
Most grateful.
I thought that in my mind, the second was on medication.
Most grateful. My Lord, we submit that the Articles 35.3 and 38 are just short and create binding obligations on the state. This flows from this court involving jurisprudence as well as a purposive reading of the Constitution. And we rely on two grounds to support this submission. Firstly, that the justifiability of the directive principles of state policies have evolved to a more inclusive and enforceable understanding, and that a purposive reading of the Constitution supports the enforceability. With the court's kind permission, I shall now proceed to my first substantive ground. My Lord, the applicant respectfully submits that the jurisprudence of this honorable court reflects a clear and deliberate evolution towards the justifiability of the directive principles of state policy. This development began in the case of New Patriotic Party versus Attorney General, the 31st December case, when this honorable court held that the entire Constitution as a whole is a justiciable document, including the directive principles of state policy, and therefore have enforcement power. By applying this principle to this present case, we can hold that the directive principles of state policy are indeed justiciable. However, there was a subsequent position in the New Patriotic Party versus Attorney General, the Gimpa case, when this honorable court approached the justiciability of the directive principles of state policy more narrowly, stating that the directive principles, in order to enforce a provision under the directive principles of state policy, most grateful, and Articles 129.3 of the Constitution, the decision of the Supreme Court are not binding. So therefore, you can be passed on your decision if you seek it.
What do you make out of the Ghana Lucian case where they say that the directives of state principles are presumably justiciable?
Most grateful, my lady. We are aware that the current position of this court on the justiciability of the directive principles of state policy is that the directive principles of state policy are presumptively justiciable. And we urge this court to uphold with this presumption in this present case. In the Ghana Lucian Operators Association versus National Lottery Authority, it was the court discussed that there's a general presumption on the justiciability of the directive principles of state policy. But there are certain areas of constraints where the presumption or the upholding of the presumption of justiciability would not apply. And we submit that these constraints do not apply this way.
What are those constraints?
They held that one was resource or structural limitations, my lady. And we submit as applicant that these limitations do not apply in this case. Because as you see in paragraph 5 and 6 of the facts, as well as paragraph 30 of the facts, it is clear that there's a concentration of resources in the capital city of Zambara, as well as other capital cities of the regions, and leaving the rural areas without any quality educational facilities. And we submit that we acknowledge that the Republic of Ghana is a developing nation and is stricken with poverty. However, and we acknowledge that there's no abundance of resources. However, we submit that the resources that are available should be shared in an equitable way, such that the entire country can enjoy the resources.
How do you determine that equitable way that you suggest the state should distribute these resources?
Most grateful, my lady. We suggest as applicants that the resources that are allocated for educational facilities and the improvement of the educational sector in general should be given to in accordance to the needs of the people.
It's something that those in the capital are undeserving of it, or they don't have the need for it.
No, my lady. But it is clear that that the people in the rural areas are suffering from very poor infrastructure and very high social wages. And it is clear that illiteracy is a huge problem in the country.
And the infrastructure is not concentrated in just the rural areas. It can't
Yes.
afford for.
Yes, my lady.
Why would you say that the rural community should be the top pick over the urban capital when you initially consider that generally anybody should be anyone within the state has a need for quality education?
Yes, my lady. But it is clear from paragraph 13 of the fact that any slight development of the educational system is first pushed to the capital cities of the country. And we are asserting that the development of the educational sector should be uniform and should be.
What is the clear paragraph 13? What is paragraph 13?
Most basically, paragraph 13 states that paragraph 13 states by a report made by the principal in one of the
Statement, right?
Yes,
The
ma'am.
statement. So he's sitting somewhere that is responsible.
Yes.
Why should what way should be a question such as this?
I do acknowledge that under paragraph 13 of the fact, it's a mere statement made by the principal. But
So
how?
you cannot be binding. Don't confide to us as though it is some reports that conclusive reports done after very serious data has been collected.
Yes, my lord. However, per paragraph 5 and 6 of the key of the existing
Going back to paragraph 5 and 6, like a sensible breaks, not recognizing the fact that paragraph 5 and 6 does not say that it is only rural areas that are suffering. It says across board, but especially rural areas. And I mean, would you agree that, all the time, would you agree that a good number of the population, right, large amounts of the population are concentrated in the capital areas?
Yes, ma'am.
Yes, so would you agree that the capital areas having more people will be less likely to suffer from the same, will suffer the inadequacies that will be the case in the rural areas simply by virtue of the fact that there are more people, so there will be more concentration going there. Resources cannot be shared equally across the board. Do you acknowledge that?
I acknowledge
So what
that,
is your
ma'am.
argument?
My argument is that although we agree that because of capital cities, a lot of people migrate towards the capital cities for development and for better opportunities. Per paragraph 5 and 6 of the key, we can tell, but before the introduction of the free education policy, the country was already stricken with poor infrastructure and lack of quality facilities in the
Which people
educational
have
system.
benefited the most under the free education we were talking about?
The part is not specific on the people who benefited from it.
From your analysis, who can you introduce from your analysis of the party that's beneficial?
I would say the people in the rural area.
So that is the equity. They are enjoying more. That's the truth.
But we submit as an applicant that without quality educational facilities, the mere access of educational facilities does not suffice to create a holistic educational experience.
Do you know why the just principles are not viable? Why do you want them to be very viable?
Why do you not want them?
Do you know why the argument that has been advanced against making the direct viable?
In relation to this present because people, it has been the view of others that the directive principles are mega aspirational and enforcing them is quite difficult because there are no steps ways in which the directive principles of state policies can be enforced.
Yes. Also, because then you will be asking us, the judiciary, to direct the executive on how to administer the country.
My lord, we do acknowledge that the nature of the present case specifically is of a socio-economic right, and therefore enforcing it will be quite difficult, especially using the normal avenues available to this court. But per Ghana Motor Authority, Ghana Motor Operators Association versus National Lottery Authority, it's the costs are suggests that in providing remedies for socio-economic matters, we should take a liberal and imaginative approach in finding remedies and not the
Liberal and what?
and imaginative approach.
Imaginative.
Yes, ma'am.
We should concoct visions.
No, my lord. So I've been out, let's start my time is up, so I respectfully request 1 minute to summarize. Most grateful.
My name is co-counsel appearing on behalf of the applicants in this matter, the Child Education Commission. In the next 10 minutes, I will address this honorable person on our third substantive argument, which is that the failure to provide quality educational facilities for school children in senior high school in Barrow is in breach of their rights to education. I will present this argument under two main headings. Firstly, that the government has breached their constitutional mandate by failing to provide quality education. And secondly, that the government has failed to meet the required standards for education. I will present the first heading under two subheadings. Firstly, that the government has failed to provide equal educational opportunities and facilities, which is in breach of Article 25 of the 1992 Constitution of Barrow. And secondly, that the government has created educational inequality. With the court's permission, I will proceed with the third subheading of the first heading of our third substantive argument, which is the government has failed to provide equal educational opportunities in breach of Article 25. Your Lordship, the applicant submits that the government has
provided equal opportunities of recovery. We provided equal opportunities of
most grateful, my lord. The applicant submits that yes, it's a work towards solving the problem. If you can't solve it entirely, it's a work towards solving the problem.
if we can't solve it, that would work. So then, if we grant equal opportunities, they will give a decision, a declaration, the effect is that equal opportunities are provided. Then it might not, what you're telling me now is it might work, it might not work. And if it doesn't work, then you jump to the next one, it comes out from another declaration.
No, my lord, the applicant's argument is that, considering the facts of the case, the quality of education in the regional capitals are far better than that of the rural areas. So if you are saying equal educational opportunities, the quality should be as much as the quality in the other areas. So therefore, the quality issue in the rural areas will be resolved.
What are 25 and 25?
Article 25 plus 1 sub plus E says that all persons shall have the right to equal educational opportunities and facilities. And with a view to achieving the full realization of that right, the development of the system of schools with adequate facilities at all levels shall be actively pursued.
What does 38.1 say?
Article 38.1 says that the state shall provide educational facilities at all levels and in all the regions of Ghana, and shall to the greatest extent feasible make those facilities available to all.
What do you make out of the condition that to the greatest extent feasible? The state says they don't have the resources to ensure that everybody has equal access in the strict sense that you require it. Wouldn't you say that that's a valid justification for 38? Give them the leeway to decide that they don't have enough money to go around, so they start from where it's more pertinent for them, where it's more pertinent the capital, which is more congested. What's your take on that?
Most grateful, Kadi. Your argument is that we do concede that the Constitution provides for them to do it, for the government to provide these educational facilities to the greatest extent that is feasible per their economic standards. However, from the fact of the case, the government is not showing there's no indication of the government's eagerness to ensure quality education in the rural areas. And we are saying that
How do you achieve that fact?
from paragraph 13 of the facts of the case,
The same paragraph 13 that
We already read paragraph 13, so the witness is like,
the applicant marks paragraph 13.
I'm more interested in how you calculate eagerness.
Pardon?
How do you calculate eagerness to come to the conclusion that the government is going to be eagerness?
Eagerness.
Tell me
It should be taken on every end. As we see before concerning the 1980 Nigeria 67, every part of the constitution has been effect, and everywhere we cannot just say that they have equal access to the opportunity without or to neglect the part that talks about access to the facilities. Because my lord, if we do not have these things, if they are studying in structure that is structurally unsound, if they do not have access to learning materials, if they have no access to qualified and motivated teachers, then the words that we have there, then in that instance, their rights become an illusion. They are not given effect because the things that are needed for those rights to be given effect do not exist. Further, we see a worsening situation that out of a country of 35 million people, more than 20% of that population is illiterate. And it gets worse. Between the 2010 census and that of 2021, the number of illiterate adults increased by 1.2 million. As such, there is a dire situation, and when institutions are so dire, it is the duty of the state to see to those that are marginalized.
So, what do you want this?
My lords, we seek that the state be compelled to provide equal opportunities, and it lies within the purview of the Supreme Court to make any order that it sees fit to give effect to Article 2.1. So, my lords, we see in 2.1 that where a person alleges that an act, or in this case, my lords, an omission, because it is stated that the state has neglected and omitted to provide these services. Indeed, in paragraph 13 of the facts, we see that there have been consistent attempts to the Byron service in charge of education, but these attempts have fallen on deaf ears. So it is not just a single incident of inconvenience, it is a long consistent pattern of worsening access to education. So as such, the court, being the safeguard of human rights, has a duty to ensure that these people have their rights. And it is the duty of the court to make the order that these states and these necessary for the human rights. Yes, my lord.
And then I said that when it comes to matters of physical policy, it's not some politics and then it's you don't think we are overreaching?
No, my lord. Because the Constitution has given the courts the power of judicial review, and the court is clothed with the power of prerogative. The court is clothed with all powers to compel
You understand judicial review?
yes, my lord.
What is it?
That where the court is able to vary an action made by Parliament or the government on the basis of that action being wrong. But my lord, that is the only power that we are setting. The court has all the powers to enforce the Constitution in the manner that it sees fit. Yes.
That's the basis of what we're trying to say. And as my colleague rightly said, it's fiscal policy is the approach raising on the emergency, which is the preview of the executive and parliament as well. Isn't that a breach of the principle of separation of powers? Because the Constitution clearly states that it's the purview of the executive and parliament to come up with a financial budget regulation and for it to be properly executed. In the same way, it's the same Constitution goes ahead to tell us that we as the judiciary cannot overreach our steps or overreach our powers and always make an order or interfere in the advances of the executive and parliament. So, what exactly do you want us to do in that situation?
Thank you very much, my lord. In fact, my lord, the argument that the court cannot have anything to do with fiscal duties was espoused in 31st December, where the AG argued that they use a situation of authority with public funds. The AG argued that when it came to public funds, the court had been removed. However, the court emphasized that where that action was inconsistent with the spirit of the Constitution, then the court had a duty to come. My lord, in some place, that this omission of supplying these things that the people need to make their right to education effective and real are ambitions that go against the spirit of the Constitution. And so, if this court declines the authorization and does not make these comments, then it means that the rights which they have are unusual and they cannot fully realize and accept them. My lords, we further submit that it is not the duty of the Constitution to submit to a budget. Budgets must submit to the Constitution. When there is an overriding burden and a duty imposed, there are no arguments that can absorb the spirit of this duty. This duty must be done. And it is not an instance of the state trying consistently for more than a period of 10 years. The situation has been worsened. And so the state cannot now then claim that we have been making consistent attempts while the situation has been consistently worsened, as we see in the fact that there has been an upward increase of illiteracy, that there has been a worsening of the fact that children are learning basically no have access to food, it is unsafe, no have access to teachers, there's a death of them in the all persons shall have the right to equal educational opportunities and facilities, and with a view to achieving full realization of that rights. C. Higher education shall be made equally accessible to all on the basis of capacity.
So 25 education shall be made equally accessible to all. In free education shall be made equally accessible to all. In free education we agree with you. And on the basis of capacity. Capacity means the ability of the government or the executive to provide, right? By every appropriate means, and in particular by the progressive introduction of free education. The government here has introduced free education, is seeking to achieve or is achieve a portion of this, but is moving on it by a progressive means. So why will you come to us and say a government compliant with this particular provision is in which?
First, we assess that feasibility is not a asset. It doesn't imply that we should ask. And that where consistent attempts have been made to draw the attention of the government to certain situation, and the government has then my boss will say that the government has further my boss.
Did you draw the attention
Yes.
of the government?
Yes.
Where is the fact?
In paragraph 13 of the facts. Yes.
What does it say?
It says that there have been consistent, repeated attempts to draw the attention of the Naira Educational Service to the geographical situation as stated in Twitter.
Because also in the fact it says that the government does not have funds.
But on us, we have no response. Of course, to countenance this situation would mean that in the interim, their rights, as fully expressed in 25, are being violated because they do not have access. They do have access to our part. It still leaves the state with a burden to carry out the other part, which is the facilities. They have
a
the
progressive means.
So
It's not an immediate one. It's progressive. There's a time.
Yes, but my lord, where over a stretch of years, a situation is worsening, the government cannot use on this that they have been attempts. If there have been attempts, then we should have seen things improving. However, the rate of illiteracy has gone up even more since the time that they carried out the last census. So as such, we cannot say that they have made attempts in solving the problem when the problem is actually worsening.
Well, you know, in Kenya, in a court, for example, for 19 years, basic education is not even free. Right? And you are trying to pay. So we remember we want to realize that how did we realize that they have to push up
And the defendants were able to establish that the fee paying policy which they carried out. Yes, ma'am. Yes,
Fight or case base because in Nigerian office, though the Nigerian people was seeking for redress from the Supreme Court for an alleged the act of the making people carry latrines. The court admitted that the Supreme Court accepted jurisdiction on the basis of public interest.
So how do the court define public interest? You haven't admitted the money for how the court define public interest.
In Nigeria.
So do you think this would be a case of public interest?
No, my lord, because the issue,
If you don't, so how would you define public interest?
public interest generally refers to the issues that may concern the public, and when a person has an interest with an ongoing act which needs to be addressed publicly.
So apart from the general conflict, do you know any other case where the courts have had to look at the issue of public interest?
Yes, ma'am.
How does the court define public interest in that case?
Lord, respectfully, I haven't accepted the definition of public interest in the court's decisions.
You have in your text not to define what public interest is. I was mentioned was as you mentioned, the Supreme Court mentioned in our mentioned a number of cases that when it's an issue of public interest, you can come to Supreme Court for the issue of human rights. Which means before you have to tell us why it is or is not a public interest, true or false. Yes. So for us to give you a definition of public interest, we need an authority to have. I don't know if you get where the issue is right now. But you can see the argument.
My lord, in Republic versus Special Prosecutor ex parte officer, the court summarized the case laws in which a jurisdiction of the Supreme Court may arise. And then it stated that A, when the provision is unclear, ambiguous,
In terms of that relation to any provision or relation to constitutional interpretation.
and the original, when you are seeking for the original jurisdiction of the
In
Supreme Court.
relation to constitutional interpretation. True or false?
Yes.
But it is an issue of constitutional interpretation and enforcement of the rights.
My lord, the applicant has quoted this issue to make it seem as a public, to make it look as if it is a human seeking for an interpretation and enforcement from the Supreme Court. That's why the respondent submits that in Yano versus Eminem, the court also affirmed that no matter how a matter is called, the real issue that arises is the writ that was brought before it, and then the nature of how the issue or the subject matter was quoted. And per the fact in paragraph 7, per paragraph 16, it is evident that the Child Education Watch is seeking for a violation of the breach of the children's right to education. Therefore, why should they go to the Supreme Court to seek for enforcement of these human rights, while the High Court can enforce these rights as well? Respectfully, must be.
The state shall promote just and reasonable access by all citizens to public facilities and services in accordance with the law. My lady, this is to the effect that the state is supposed to provide accessible facilities to the citizens. However, it is our submission that this is dependent on the resource availability of the state.
So the state can conveniently say that we don't have enough resources and intentionally exclude other citizens from certain rights that they are otherwise entitled to. And then we cross our legs and say there's no funds, but there's funds for other people to enjoy. What was the for deciding which part of the country should benefit from the so-called inadequate resources, and why should those people get quality education as opposed to those in the rural communities?
My lady, our submission is that the government of Byron is progressively realizing the right to education.
How do we determine that you are progressive?
We introduced the free senior high school policy to deal with the high illiteracy rate of the country, which was highlighted in paragraph 3 of the fact.
Your opponents are not arguing the relevance of the free education policy. They are arguing the quality of education, this will put effect on the academic performance of a particular set of people. So yes, we have done free education, but that is the problem, because based on the free education policy, there's an influx of people in rural classrooms, and they are not doing well in schools. And you say that you don't have money.
My lady, that brings us to paragraph 38 of the Constitution. Article 38 of the Constitution, which provides that the government is supposed to provide, which is the effect that the government must provide free and fair. The government must provide. The government must ensure the right to education by providing the necessary facilities. However, it was stated that this is to the greatest extent feasible, and it is also stated there that it is based on availability of resources.
So tell us, why is it justified that with the scanty resources that the state arguably has, certain regions had the luxury of getting the quality that others did not have? What was the basis of defining that distinction?
My lady, Byron, according to paragraph 1 of the facts, is a developing country.
Yes, we
And
understand
even
that. My question is, even with the status of educating and developing country, right? Your applicants say that if you have 50 million Ghana cedis and you have 5 regions, it should go across, every region should have 1 million. But in reality, only 2 regions have benefited from 5 million. What is the justification for that? Because clearly, even if it's country, they say that it should go around equally so that you can see the progress money everywhere. But you concentrate on one side and leave the other. Why is that justified?
My lady,
Yes.
it can be logically inferred from the fact that the rural areas, it was stated in the fact specifically that the country is faced with high illiteracy rates. However, it can be logically inferred from the fact that the rural areas are the ones that suffer this most. And as such, since the free senior high school policy is to the effect that children can attend school for free, it is clear that it is in those areas that the schools are going to be cheap. Besides,
you are trying to solve the issues of illiteracy, we need to choose a policy that gives you the worst of infrastructure, resulting in the worst of academic performance. You're already creating high levels of illiteracy, but people are in school but not necessarily doing well in school, so you don't solve the problem. Do you agree with that?
yes, Ms.
So you mean that the state is not really giving the quality of education, wouldn't you say so?
No, certainly not mine.
So what is the justification for the education, and how do you reconcile that with your policy trying to solve a problem that you have clearly outlined is not solving?
My lady, our simple argument is that the state is progressively realizing their right to education. My lady, it is undoubtable that those in the rural areas are facing inadequate facilities in terms of these rights to education. However, it is clear that these rights cannot be enforced immediately. It is based on progressive realization.
That was your first point of the negotiation.
Most grateful. On our first point of the first issue, which is whether the Supreme Court has jurisdiction to hear the matter under its original jurisdiction, our submission is that the Supreme Court does not have jurisdiction to hear the matter under its original jurisdiction. My lady,
What is the original jurisdiction of the Supreme Court?
the original jurisdiction of the Supreme Court, according to the Black's Law Dictionary,
Yeah.
the original jurisdiction of the courts According to the Supreme Court, Article 130 clause 1 of the Constitution provides that the Supreme Court shall have jurisdiction in enforcement of all matters arising from constitutional enforcement or interpretation and matters arising from ultra-vires enactment. My Lord, it is therefore our submission that the Supreme Court does not have jurisdiction to enforce this particular. The Supreme Court does not have jurisdiction to hear this particular matter, and we base this.
No, I'm not satisfied. I'm not satisfied. What is the original jurisdiction of the Supreme Court?
If it's pleasing the court, counsel will explain to the Constitution.
No, there is no constitution where you get an answer for it. So I'm asking you directly, what is the original jurisdiction of the Supreme Court?
Article 130 clause 1, which per the side notes provides for the original jurisdiction of the Supreme Court, is to the effect that the Supreme Court has the jurisdiction to enforce constitutional matters, to enforce all matters that are, to hear all matters that arise from constitutional enforcement or interpretation.
But I want you to address that or respond to the applicant's submission that the Supreme Court has jurisdiction because this matter is based on the sheet of interpretation as to what is the metric for defining the quality of education and how do you include or exclude people. It also said that they are taking this on enforcement, which is calling on the court to ensure that there is some level of attention by the state to rural community. So clearly there seems to be issues of interpretation and enforcement by the applicant. If you beg to differ, clearly explain how that point that they have made is not true within the given circumstance.
My lady, in terms of interpretation, it was stated clearly in the case of Republic versus Tribunal, ex parte Acosta. It was stated in the case of Republic versus Special Tribunal, ex parte Acosta, 1980, by a specifically
Still no case like that. Don't worry about that.
It was stated in that particular case that matters of interpretation, the matters concerning the interpretative jurisdiction of the Supreme Court arises where there is ambiguity in the words of any part of the provision of the Constitution. It goes ahead to say that, and as such, if there is no need for, if there is no ambiguity in such.
It doesn't really talk about interpretation. That sounds like
My
when you
name.
read it after that, do you even know the fact of my case?
Respectfully, I'm not alerting my mind to that.
Let me help you small. Hi, does any of the speakers know the facts of the outside? Oh, right. Please proceed.
It is therefore our submission that since there are no ambiguities in the specific rights they want to enforce, there is no need for constitutional interpretation because they are alleging the violations of right to education, which is enshrined in Article 25 of the Constitution. And
also, even in that circumstance, right, we also argue that there are one culprit who are pursuing an action in the interest of the public. And so there are no issues of interpretation, but then the court has held that when they borders on public interest, we have the Supreme Court as jurisdiction. How do you reconcile that with your fixation on interpretation?
we recognize the fact that Article 33 provides that the person must have personal interests in matters concerning breach of human rights before he can invoke the original jurisdiction of the High Court. However, it is our submission that the Article 140 clause 2, which to the side note provides for the jurisdiction of the Supreme Court properly, of the High Court properly so called, it's not clear on as to whether the person must have a personal interest in the matter or not. And besides,
Can you conclude on that your
it is therefore the humble submission of the respondent that the Supreme Court does not have jurisdiction to hear the present matter under its original jurisdiction, and Article 38 and Article 35 clause 3 are not justiciable. Respectfully submit. Are you familiar with the issue you wish to address? The issues you wish to address? Come again? No, the first one I'm familiar with. You're not familiar with it. So you can't address us on this point on Article 140.
Article 140 grants the Supreme Court
The
High Court, sorry, the High Court.
No worries.
Respectfully, my lord, appearing as a co-counsel for the respondents on behalf of the Republic of Ghana. In the next 12 minutes, I will address this humble court on the third issue, which is whether the failure to provide quality educational facilities for high school children in Ghana constitutes a breach of their right to education. With the kind permission of this honorable court, I will advance arguments on my third issue. Most grateful, my lords. I will base my argument on two grounds. Firstly, Article 25(1) of the 1992 Constitution of Ghana and Article 13(2) of the International Covenant on Economic, Social and Cultural Rights emphasizes reasonable steps towards the right to education. Secondly, Article 38(3) of the 1992 Constitution of Ghana and Article 21 of the International Covenant on Economic, Social and Cultural Rights obliges the states to act to the full realization of the right to education. My lord, paragraph 2 of the fact, BIRA is part of the international community. In paragraph 2, FFE states that in paragraph 2, FFE states that BIRA obeys all. My lord, paragraph 2 of the fact states that BIRA is a party to the international community and has signed all its treaties in international law. Therefore, they are the international.
So you can probably say them like a certain act of parliament to us.
No. My lord, this is binding on the state because the state is a party to the international community. And the international covenant on economic, social and cultural rights is a binding agreement.
What does the Constitution of Ghana say in relation to the enforceability of international treaties? At what point do it become binding or applicable in either state?
My lord, Article 75 of the 1992 Constitution of
So
Ghana.
you know it, then address us properly. Stop doing the
You mentioned Article 75.
My lord, Article 75 of the 1992 Constitution of Ghana outlined the process of ratifying international agreements. It states that the president may execute or cause to be executed treaties, agreements, or convention in the name of Ghana. Clause 2. A treaty, agreement, or convention executed by or under the authority of the president shall subject to ratification by an act of parliament or a resolution of parliament supported by the votes of more than one half of all the members of parliament. And paragraph 2 of the fact states that BIRA has a global reputation for abiding by all its international obligations, and most of its treaties it has entered to has been ratified by the national parliament. My lord, with your kind permission, I will advance argument of the first one of my substantive argument, which is Article 25(1) of the 1992 Constitution of BIRA and Article 13(2) of the International Covenant on Economic, Social and Cultural Rights emphasizes reasonable steps towards the right to education. My lord, Article 25(1) of the 1992 Constitution provides
definition of barrier. It provides that the state subject to the availability of resources. So the reasonable here is subject to the availability of resources of the state.
Africans argue that you have enough resources, regardless of how country says, to go around every region, including the rural communities, and that the progress that you argue should cut across the board and not be concentrated. So technically, you are supposed to be responding to that position that you have now, even if you don't have enough. You should translate that reasonable step you are taking should be seen across the board, but we're not seeing that. Wouldn't you say that that's a violation of your constitutional obligation?
No, my lady, the same Article 38 also provides that the state, subject to the availability of resources, provide equal and balanced access to education. So if the country does not have enough resources, it cannot provide equal and balanced access to
the
education.
applicants there, because the balance they are looking for is that, again, with the same example like this, we have 5 million, not 5 million, 1 million distributed. Then that 5 million is being distributed in 2 regions.
My lord, that is
the
why,
justification for that.
my lord, the government has, paragraph 7, has implemented the free senior high
The
school
free
policy.
education policy is the problem.
However, the free senior high school policy is benefiting both the rural areas and the
And
urban
I
areas.
asked your co-counsel that you say you are putting the free education, putting together the free education policy to deal with issues of literacy. But the people in the local, like rural communities, do not necessarily resolve issues of literacy. Why? Because when they get to these schools, they don't have adequate resources to be able to excel in the school. So it's like a cycle where they come back to being illiterate because their counterparts in other regions have quality education. So again, how are you solving the problem? Because you're not answering the question of why is it justified that the state give other people quality education and neglect of others?
My lady, it is not expressly stated in the fact that the urban areas have quality educational
Have
facilities.
you looked at paragraph 5 of the text?
Paragraph 5 of the fact says that various educational systems, despite showing significant progress in terms of access,
Second one, repeat that, the second and third one.
one of the most pressing issues is the evidence of lack of adequate infrastructure, especially in rural areas.
Especially in rural areas, which connotes that basically a huge problem in the rural areas. What did you say? So from logical inference, you can say that the rural areas are left behind. So why is the state justified? Is there any law or any legal argument that you can advance to say that the state is justified in its decision to discriminate against the rural community?
My lord, the state is not discriminating. It is progressively realizing the right to education. Progressive realization, as defined by the UN Committee of Economic, Social and Cultural Rights, the process of progressive realization constitutes a recognition of the fact that full realization of economic, social and cultural rights will generally not be achieved in a short period of time. This shows that the government is gradually working towards progressively realizing the right to education at both the rural areas and the urban areas.
Since 1992, and we should continue to allow them to realize it so that in 30, 50, 80, it's even the same story.
No, my lord. My lord, paragraph 2 states that, paragraph 3 states that 67 years after independence, the country is still grappling with poverty. This clearly shows that the government is
Yes,
beginning.
this is the contradiction of the African. We are saying that 67 years, there's nobody to go you people to further. That is why you go and bring them on themselves and so they want us to go you to further. And you see, it is in line, they are not just saying go you to further, like, say, to bring in their own or importing their own ideology. They are just taking reference to the Constitution. So why should we not do as they are saying and based on the constitutional provisions for you to write?
My lord, the level that no one has.
Don't go into territory where you don't know.
My lord, it says the state cannot give what it has. And then based
You
on
cannot what?
the
Cannot give what we have.
I told you not to go into territory.
has, the state has to make sure that other crucial sectors such as healthcare, infrastructure, security, and other ones, the state must make sure that these available resources are equally distributed among other crucial sectors.
So would you say, because when she was here, counsel for the applicants, or who was for the applicants, argued that or made a point that, in fact, in response to the question she was asked, she said that in rural areas suffer everywhere, in every sector, not just education, healthcare, labor and industry, generally everywhere across the board, they face these challenges. So when the arguments you are coming to talk about, we do not persuade, because you saying that you have to apportion to security and other things, we are not swayed because we already know that she already made the point that over there to rural areas, unless you are coming to say that the security and healthcare you are talking about is within the urban areas, which will give more credence to their point that you are forgetting about the rural areas.
No, my lord. The urban areas are also facing similar challenges. When you look at the free senior high school initiative, both the urban areas and the rural areas are suffering from poor infrastructure, high student-teacher ratio is so wrong with the state,
like taking down the policy of more problem.
Article 225(1) of the 1992 Constitution of Ghana, the right of education must be recognized progressively. So the state is
Progressively was being done before free education. Wouldn't you say so? Where people were getting quality, and now the quantity and they are not excelling in school, especially due to the rural community. Why shouldn't the court say that the free education policy violates the rights of specific people, which is the rural communities?
My lord,
Free education.
more space to my name. Before the free senior high school was implemented, both the rural areas and the urban areas were suffering from issues when it comes to rights to education.